The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar, so please listen carefully. People versus Albert Jackson for the appellant.
Yes, Your Honor. Emma Schriefter from the Office of the Appellate Defender.
5 and 2.
Thank you.
For the respondent.
Karen Schlossberg for the people, Your Honor.
5 minutes. Dilberto versus New York. Dilberto, I'm going to ask that you keep your mics off until it's time to speak. Dilberto versus New York Presbyterian Hospital for the appellant.
Yes, Kevin O'Reilly from the law firm of Keller, O'Reilly and Watson.
That's 5 and 2.
Thank you.
For the respondent.
Carolyn Canzanieri from Decolator, Cohen and DePrisco for the respondent.
That's 5 minutes.
Thank you.
A. Children for the respondent. I'm sorry, for the appellant.
Adam Deming from the firm Proskauer Rose.
6 and 2 for the respondent.
Yes, Your Honor. Jeffrey P. Berman, appearing for respondent Cardinal McCloskey Services.
3 minutes. I'm sorry.
Marcia Egger from Legal Aid Society for the Children.
3 minutes. Astapina versus West Farms. There are 2 appeals. Both are submitted. People versus Romulo Cepeda for the appellant.
Good afternoon. Ivan Pantoja on behalf of the appellant.
6 and 2 for the respondent.
Good afternoon. This is Sheila Bautista on behalf of the people respondent.
5 minutes. People versus Thomas Allbrooks is submitted. P and H and R Solutions versus Braun is submitted. Maimoni, versus Huey is submitted. People versus Angel Pajes is submitted. Zittman versus Sutton LLC for the appellant.
Good afternoon, Your Honor. Robert E. Land for the appellant.
5 and 1 for the
Thank
respondent.
you.
Good afternoon, Your Honor. For the respondent, Robert Marino.
That's 5 minutes. Marcello versus Fabius is submitted. Waverly Stores versus Waverly Muse for the appellant.
Stephen Kirkpatrick from Romer DeVos. Good afternoon, Your Honor.
Good afternoon. 6 and 1, Mr. Kirkpatrick. For the respondent.
Stephen Rabinowitz for the respondent.
6 minutes. Cadalso versus Russ is submitted. Fletcher versus Niera is submitted. Counsel, please remember, as always, that we have your briefs, we have your record, we're familiar. I'm going to just ask that everyone, right now. Okay, thank you. As I was saying, please remember that we have your briefs, we have the record, we're fully familiar with the facts of your cases. So please go directly to the points the most important points you wish to make. Also, as is customary, please don't speak when a justice is speaking. It's particularly important during our virtual arguments so that we can hear one another, and importantly, so that you can hear the question that is being asked. And finally, as an example we've just seen, please keep your mics muted so that we can limit the background interference. Thank you for your cooperation, and we are ready to begin. The first case is People versus Albert Jackson.
Yes, good afternoon. Moment is there we go. Okay.
Yes.
Good afternoon. My name is Emma Schriefter from the Office of the Appellate Defender on behalf of Mr. The prosecution did not establish all elements of the.
Could you just wait 1 moment? I'm sorry. You're going to sign off and sign back on?
This happens. So something's wrong with my system here. Let me turn it on and come back on.
If you sign off and sign back on, try that.
Let me try that.
why don't we just wait a few minutes to see if Justice Mendez can come back on? Otherwise, he'll listen with his mic on, muted.
Does that work now?
Yes, it does.
Okay, great.
I don't see you, but we don't have to see you. We have to be able to hear you, and you have to be able to hear us. So, Ms. Schriefter, if
Yes.
you would begin again. Thanks for your patience, everyone.
No, thank you. The prosecution did not establish all elements of the aggravated family offense. Because the court failed to follow the clear mandates of Criminal Procedure Law, Section 200.60, this conviction is not valid and must be reduced to the underlying misdemeanor of assault in the third degree. The prosecution was required
Counsel,
to establish—
were these issues preserved here?
No, they were not preserved, but this court should use its interest of justice jurisdiction because this error affected Mr. Jackson's fundamental right to a fair trial to have all elements established. And furthermore, the court here had two errors, not just one. The prosecution did not establish that Mr. Jackson had been previously convicted of a specified offense against a family member or a member of the same household. The court never properly arraigned Mr. Jackson correctly on the special information. Under the criminal procedure law, the court must advise the defendant of his right to admit, deny, or remain mute about a prior conviction, and that did not happen here. The court only—
I was just going to ask, didn't the court ask him, stop him at certain points when he was going to speak before the allocution, and then when she started asking questions, ask if he was ready to plead, asked his attorney if he was ready to plead before proceeding here?
Yes, but the court still never specifically advised Mr. Jackson that he could admit, deny, or remain mute. The only question of Mr. Jackson was, quote, "Is it true that you were actually convicted of assault in the third degree?" And under the statute, there must be this advisement of the rights to admit, deny, or remain mute. And those conversations about the special information were not sufficient to provide this advisement. It's clearly prejudicial on this record that because Mr. Jackson alerted the court on several occasions that he had a question, he wanted to make a statement, and he was never given the opportunity to do so. It's clear that then it's possible, had he been properly advised, he would have made a different decision and would have perhaps denied or remained mute about the prior conviction.
You agree that there doesn't have to be any particular litany here?
No, there does not have to be a particular litany, but the court still must advise that there's a right to deny or remain mute, and that advice was not given. That he was only asked whether it was true that he was convicted of a prior specified offense here, and just asking, "Is it true?" only asked Mr. Jackson to admit, but there's no mention of his right to deny or remain mute. And because this procedure was not followed correctly, the prosecution did not prove this element at trial. The elements were not all established, and this court then must reduce the conviction to the underlying misdemeanor of assault in the third degree. And if there's no further questions, I would ask this court do that reduction. Thank you.
Thank you, counsel.
May it please the court. Oh, sorry, Judge.
I was just going to call on you. Go ahead.
Thank you. May it please the court. I'm Karen Schlossberg on behalf of respondent. This case, as my adversary concedes, there was no preservation here, and this case shows exactly why preservation is important. Prior to the trial, The prosecutor was very clear on the record that she was prepared to prove this element. She had the evidence ready.
But we're really talking about an allocution here, not just attorneys and the judge having conversations.
Absolutely.
This defendant seemed to interrupt a couple of times, indicating confusion or wanting to either question something or make some sort of statement. The judge rightfully stopped him, told him to talk to his attorney, but there was really no, well, let me ask you, is there an allocution here?
There was definitely an allocution here. And, you know, Ms. Schriefter keeps saying that the only question that was put to defendant was, is it true that you have this conviction? But that question came after days of pretrial discussions, during which the prosecutor and the judge and the defense attorney, with defendant present, talked about the fact that if he had the opportunity to plead to this, or I mean to admit to it, or the prosecution was going to prove it. That was mentioned in front of him at least 4 or 5 times, and it is true.
But that's not an allocution. There's a very good reason for that, because when the attorneys and the judge are talking in legalese and quickly or whatever, I wouldn't expect everyone in the court to understand it, especially not the defendant. And he interrupted and wasn't questioned. So we have to at least take from that there was confusion. So why don't we look at the allocution, the part that you're saying is the allocution itself?
Okay, the allocution itself was absolutely clear, but also I just want to address that idea that he tried to speak and wasn't permitted to speak, and that therefore there might have been some confusion. And I think if you actually review the record of those pages from the transcript, the opposite conclusion is the only one that can be drawn. The judge was incredibly solicitous of the defendant and very concerned that he understood, and her only admonition to the defendant was, why don't you talk to counsel first? And she was very clear. She said, and if you still feel you want to address me, I'll hear from you or your counsel tomorrow morning. He never raised.
Agreed. He was very concerned not to have the defendant speak without counsel's permission. She wanted him not to speak so that he could speak to his counsel and be advised.
But also, the point I'm trying to make is that the judge was also extremely concerned that defendant understood what was going on. And she kept asking the attorney, does he understand? Have you discussed this with him? Do you need more time? The attorney said, we need more time. She gave them more time. They addressed it again the next day. The attorney asked for additional time. And when the defendant tried to speak at one point, she gave them more time then. And there was no hesitation there was no indication whatsoever on the record that the defendant did not understand what was going on. I don't know what it was that he wanted to say, but he obviously thought better of it and decided not to say it. But when it came time for the actual—
advised by the court not to say it.
He was advised by the court to speak to his attorney first and then decide if he wanted to say it. And then the next day he chose not to. And when it came time for him to do the allocution, there was no hesitation or indication that he was unaware of what was going on. And the judge, by that time, it had been stated on the record, I think 4 times, that either the prosecution was going to prove this or he was going to admit it. And the judge made sure to say, you understand why this is happening so that the evidence is not presented at trial. And he indicated that he did understand that. And then he admitted it. I don't think there's anything in this record that suggests that this defendant was not advised or did not understand what was happening. I think a brief review of the few pages I cite in my brief absolutely would dispel that notion. And there's a reason why both of these arguments are unpreserved for review. The counsel didn't raise any concerns because the defendant understood what was happening and because it was clearly in his interest to admit to this prior conviction, and he did. And had they raised any issue, the prosecution was prepared to present the evidence. And so for them to come in now and say that this element wasn't proven is not fair. And I also just want to also address the prejudice. There's no showing of prejudice at all. Ms. Schriefter is saying that he may very well have decided to take a different course of action if he had been differently advised, but there's no indication that that's true at all. In fact, the opposite conclusion is the only one to be drawn from the actual record. It's clear that he understood what was happening and that he made the right and rational decision to admit this crime rather than having it. Unless there are any other questions.
Thank you very much. We're back to Ms. Schriefter.
Yes, I would like to say that it's not counsel's obligation to advise Mr. Jackson of his rights. It was the court's obligation to do that. And it's also not under the statute that a defendant must understand his rights, but that the court must affirmatively advise his rights. So these conversations about the special information were still not sufficient. And furthermore, these conversations were never directed towards Mr. Jackson. These conversations were first between the prosecutor and the court, and then the following day between the court and defense counsel. But even if there were conversations about the special information, Mr. Jackson was never directly addressed by the court, and this was not sufficient to advise him of his rights under the statute. And additionally, it is clear from the record that Mr. Jackson was confused, and he was never given the opportunity to make his statement. And we don't know from his conversations that Mr. Jackson, again, understood these rights from conversations with defense counsel. If there's no further questions, I ask that this court reduce to the underlying misdemeanor.
Thank you. Thank you both. Dilberto versus New York Presbyterian Hospital.
Yes, for the defendant, appellant Kevin O'Reilly from the law firm of Keller, O'Reilly & Watson for New York and Presbyterian Hospital.
And
You
for
may
the, oh, sorry.
May I proceed?
Yes, please.
Okay, thank you. This case involves two police officers who were guarding a prisoner at New York Hospital who took over the care and custody of the patient at around 3 p.m. and observed him for 6.5 hours in the emergency room. It was
Mr. O'Reilly,
Yes.
the nurse who worked for New York Presbyterian,
Yes.
Did she assume custody and control of the prisoner by asking the police to leave the room and then close the curtains and then giving the prisoner, I think first she actually asked them to unshackle him so that she could test him, asked them to leave the room. She closed the curtain and then she gave him a telephone before walking out and telling the police that she was done and that she gave him the telephone. Didn't she, by those actions, assert custody and control over the prisoner?
Absolutely not, Your Honor. The sequence is this: the officers had observed this patient for 8 hours. The nurse's primary concern is to treat this patient who is in pain, who needs to be treated for. That's why he's in the burn unit. She simply asked the officers, in order for me to do this, can you unshackle a hand and free up the leg that I need to address? And Officer
those weren't, that wasn't really the problem necessarily. It was then asking the officers to leave the room, right, directing them to leave the room, closing the curtain, and giving the phone.
Right.
Those three things were really
right. In terms of asking, she had no authority and no ability to direct the officers to leave the room. She asked them. And in fact, the officers abrogated their duty to the patient by leaving the room. Now, in reality, they stepped right outside, but certainly that stepping a foot outside the room does not.
And so your position is that she should have said no, the officers should have said no to her?
They could have said no. They could have said
no. Your position that was part of their duty to say no, where the officers were not leaving the room so that you can give her medical care and that it's inappropriate for you to be alone with a patient?
Well, no, the position is it was their responsibility to assess the safety of the situation. And Officer Diliberto testified that he believed that it was absolutely safe for them to take off one shackle of the arm and one shackle of the leg and to step outside while the nurse admittedly gave a treatment which was extremely painful.
So what about the intervening act then of giving the telephone? Let's even say it was okay and they thought it was okay to leave her alone, but then she did something that had nothing to do with medical care and actually handed over a telephone, which could be used as a weapon and was used as a weapon. Isn't that an intervening act?
No, there was no indication that she actually gave the prisoner the phone. The phone was.
There was testimony that the phone was not within reach, that the officers had put the phone so it wasn't in reach, and she said her statement was coming out that she gave him the phone. She let him make a phone
When she
call.
came out, she said the prisoner is making a phone call. Is that okay? Officer Diliberto's testimony was that he didn't know where the phone was. He just was sure it wasn't within arm's length. Officer Vaughn
Within
testified.
arm's length. Okay.
Right. Officer Vaughn testified that he didn't know where the phone was. So, but anyway, even if she had allowed him to use the phone, the officers, if this was a dangerous instrumentality, as they're claiming, they should have said to the patient and we're taking the phone with us, or don't let him use the phone. The officers have said repeatedly that they had similar circumstances where patients were allowed to use the phone. They never said to this nurse who was basically treating the patient that you should not let this patient use the phone. And for a phone to be considered a dangerous object, should they have taken away the pillow in case the officers came in and the perp would try to suffocate them? I mean,
well, counsel,
I
we
think
can
you would
agree,
probably
can't
find
we, that a
cases
pillow and a hard phone, a plastic hard phone, are not the same thing, right?
Right.
And giving him the phone had nothing to do with medical treatment. Nothing. There's nothing that a nurse needs to do to treat a patient by giving him a phone. And she said, I mean, we can quibble about it, but
Right.
there's at least an issue of fact that she gave him the phone. And we all know that he took the phone and hit the officers, correct?
Well, yes.
We're all in agreement with that.
Yes, absolutely.
And you're saying that based on that and that scenario, that your nurse did something that had nothing to do with medical treatment, gave him a hard object with which he later hit the police, and you're saying you're denying all liability for that?
Saying that she did not assume a duty to the officers, as the Zerba case clearly shows. The other thing,
isn't there a question of fact, as Judge Scarpullo indicated, and Justice Kern was also suggesting? Isn't there a question of fact in that, in those facts that have been discussed, and at least the ones that are agreed upon with regard to the phone and the defendant being in possession of the phone and it not being medical treatment? Isn't there an issue of fact there raised?
Even if you assume that she did give him the phone, and I will say that for the purpose, which I understand for the purpose of my argument, after the phone was in the prisoner's possession, the officers then re-entered the room, and the officer's testimony was, at that point, with the patient shackled and with the patient on the phone, he presented absolutely no risk or threat to anyone. So at that point in time, even if you assume that the nurse had custody and control for that period of time she was treating the patient, when the officers re-entered the room, they reassumed complete custody and control, and the actions that went forward from theirs was entirely within their decision. And
okay, let me hear from opposing counsel now. Thank you.
Thank you, Your Honor.
May it please the court, this is Carolyn Canzaneri for the respondent. We respectfully request that the lower court decision be affirmed. The defendant failed to make a prima facie case.
Counsel, Mr. O'Reilly has said that when the officers returned to the room, they had complete control and custody over the situation, over the prisoner, control over the circumstances, and that they created what transpired after that. Asking, telling the defendant, I think, to get off the phone.
At all times, once the hospital did request for medical attention to the plaintiff who had a self-inflicted burn, they had custody and control of the patient. The Alex Rodriguez, who is the defendant's witness, said the hospital was responsible for all medical issues. The nurse gave the phone to the prisoner. The plaintiff did testify that he never saw a patient before be given a phone, be allowed to use a phone, and the defendant hospital should have known that this phone could have been used for an unintended purpose, such as a weapon in this case, injuring both of the plaintiffs here. The nurse stated she didn't know the protocol, whether a phone could be used, and she still gave the phone to the prisoner. After giving it,
this was a defendant. This was a person who had committed or was alleged to have committed a crime. Wasn't it the responsibility of the officers who were there to know what they were supposed to do? I mean, they wouldn't have just left him unshackled in the bed, for sure. They knew it was their responsibility to keep him cuffed to the bed in the same way. Didn't they know that it was their responsibility to remain with him at all times? I mean, isn't this really more of a question of whether they knew what their role was and how to carry it out?
With regards to that, Alex Rodriguez, who was for the hospital, stated that security was supposed to be present from the hospital, a supervisor and 2 officers, which was never provided. They failed to follow their own procedure, which was to make sure there was the safety of the patient, the visitors, and staff, which was in the record 428 and 595. And the hospital was aware in their own medical records that this patient had fits of rage, argumentative, was violent, was combative, which was on ecstasy, had a psychiatric disorder, and they still gave the patient a phone. No, they should have known that this would have been used as a weapon. Once it was in their hands for medical purposes, the custody and control was then of the hospital. And certainly there's an issue of fact in this case. And then, unless anyone has any further questions, the lower court decision should be affirmed because the hospital did have a duty of care to the patient, the visitors, and the plaintiffs in this case. They did assume custody and control once they gave the phone and was providing medical care. And they certainly had notice of the violence of this patient because it was written in all the records at 388, 598, 618, and 621 that this patient was violent, combative, aggressive, and showed fits of rage.
Thank you.
Thank you,
Mr. O'Reilly.
Yes, I'll be brief. I believe that the lower court decision essentially turned everything on upside down. In other words, they are saying that a nurse who is unarmed and untrained has a duty to protect police officers who are armed and trained and who had been assigned the duty to stay with this patient at all times, who abrogated that duty by stepping outside, and who then came into the room where there was no threat presented to anyone and embarked upon a course of action that resulted in injury to themselves. And so there are certain things that you may talk about law in this, there are certain things in life that are right, and there are certain things that are wrong. And to hold a nurse who is trying to treat a patient responsible for the actions of this prisoner, which were brought upon the police officers by themselves, I think it was wrong for the lower court to do so, and I think it would be wrong to affirm that decision.
Thank you, Mr. O'Reilly, and thank you, Ms. Canzanieri. Thank you both.
And thank you for your consideration.
Thank you. Be safe.
Thank you. You too. A children, or children A, I should say. Mr. Deming. Attorney for the appellant?
Yeah, I think he's trying to unmute himself. That doesn't look like he's getting very far.
Okay, we'll wait. I can't see Mr. Deming, so I'm going to move on to the next case and then come back. Mr. Deming, if you're there, and I assume you are, maybe you want to sign off and sign back on?
Yeah, he's giving you the thumbs up. He hears you.
He said, okay, he wants to do that. Okay,
Yeah.
I'll move on. Okay, People versus Romulo Cepeda for the appellant.
Yes. Ivan Pantoja, the Legal Aid Society, for Mr. Romulo Cepeda.
Yes, go ahead and begin.
May it please the court. Mr. Cepeda's guilty plea was not knowing, intelligent, or voluntary for 2 reasons. First, there is absolutely no dispute that the trial court misdefined the offense to which Mr. Cepeda was to plead guilty to. And second, the trial court did not adequately inform Mr. Cepeda of his Boykin rights.
So I just have to ask you again, this case, like the last one, were the issues preserved here?
It was not preserved, but I believe the preservation exception applies for two reasons. First, as this court held in People v. Lawrence, the preservation exception applies to situations not only when during the elocution a defendant negates an element of the crime, but also when the court leaves unsatisfied an essential element.
But he could have, this is not a thing where he had no opportunity. He was sentenced. He could have withdrawn this plea that was inappropriate if he thought so. I mean, there was a clear opportunity to preserve
I would say that
something about it, to address it.
Well, I would say that Mr. Cepeda actually had no practical ability to object to the court's error. And I think it's important to highlight here that what we're dealing with is an omission. And as the Court of Appeals has held, Mr. Cepeda could hardly be expected to move to withdraw his plea on a ground of which he had no knowledge. And here, the court, along with the court clerk, all of the parties did not see that the court had not properly allocated Mr. Cepeda and left out the critical element that differentiates a misdemeanor trespass, for example, or non-criminal.
So you're saying this can only be done on an appellate review by going over the transcript and reading it? Is that what you're saying? That the attorney at the sentencing had no ability to do this?
I would say that he didn't because no one knew that there was this error. This case is the rare case that I think much of the preservation exception cases talk about, in that the error here occurred much earlier than in the typical case. The error here occurred with the court. So it's as if, for example, Mr. Cepeda had no opportunity to negate an essential element. Because the court's error occurred earlier, no one knew about the error. And regardless of whether there was, a time period between the plea and the sentence, no one would have known to object to that error to preserve it.
There's a question from Justice Kern, I believe.
You couldn't hear me, or it's just disregarding me? That's why I hesitated.
No,
I'm sorry,
sometimes
I didn't hear you.
It's hard. There's a delay, I've noticed.
Okay, my question was, if you could see the argument this is what Justice Renwick just asked, if you can see the argument now, why couldn't it be seen after the plea was given? What's any different about you raising it now versus it being raised after the plea was given in a motion to withdraw or some subsequent period before the appeal? What distinction is there other than maybe that you're, a more astute attorney, but that's not really the standard?
I understand. I think the benefit that I have is the benefit of having the transcripts and a significant amount of time to review all of the materials. And I think, this was not necessarily a case where the plea and the sentence happened at the same time, which is much of the preservation exception cases deal with. There is a time period, but still that omission.
I never saw a case which makes a distinction between having more time at the appellate level versus having more time after the plea. That is a distinction that saves you in terms of the preservation because you have more time now to find it. That is not in the case law. So that's what how are you fitting your argument into the existing case law in terms of preservation?
Well, I would say that it fits. I take your point, and I would say that it fits first under People v. Lawrence in that an essential element was left unsatisfied. And so that fits within the preservation exception. But also under Lurie, where he could not have known, Mr. Cepeda could not have known to object to it. He knew that, for example, he was taking a plea that day, but it was the court's responsibility. And they needed to have a record affirmatively showing that he had a full understanding of what the plea connotes and the constitutional rights he was waiving. And the court didn't fulfill that responsibility. I know my adversary, and of course, there is no particular litany that's required, but that doesn't necessarily mean that obviates the trial court's responsibility to properly define the crime. Let the defendant know exactly what he's pleading guilty to, and then inform the defendant of the Boykin rights that they're waiving. And I would also say, I guess, in the event that your honors feel that preservation is required, I would ask that you still reach this issue in the interest of justice, given the errors that were made in this case and the rarity of this case. I think it is quite the rare case when a court and everyone else misses this critical issue. In fact, the court's allocution could have fit numerous crimes. Yes?
No, I was just saying, yes, that's true. I think what you're saying, though, is that it's the court's responsibility, and one doesn't usually obtain a transcript and review the transcript every time there's a plea to ensure that the court was accurate. And without doing that, everybody's assuming and everybody's moving quickly, and that's how it's missed. I think, is that your point?
Yes, Your Honor, it is.
Okay, let's thank you. Ms. Bautista, I believe?
Yes, good afternoon, Your Honor. Can you hear me?
Yes.
Great. Thank you. May it please the court. My name is Sheila Bautista. I represent the people in this case. Your Honors, with respect to
Ms.
the
Bautista, let's start off where Mr. Pantoja left off, with the fact that, you know, the way courts work, we're all expecting everybody to do what they're supposed to do. The judge is supposed to give a proper allocution. Nobody's really running back and asking for the transcript so that they can, ordering the transcript so that they can review to make sure. So how is the defendant in the position to ask to withdraw the plea?
The case law from the Court of Appeals, and repeatedly in this court, as recently in last year in People v. Kapakis and People v. Manley, have held that when there's time, like there was in this case, 6 weeks between the guilty plea and the sentence, that gives the defendant the practical ability to object and preserve the claim. And as recently as last year, this court—
It is the practical ability, and yes, the courts have said that, but is it practical? But is it practical?
Yes.
Is it truly, in the way the courts work, is it practical? Is that what we're going to be asking to be done? I mean, I know that's what the cases say, so we'll be having defendants ask the courts to pay for a transcript so that it can be reviewed after every single plea.
Your Honors, that's what the courts have repeatedly held. This is unlike those cases. This is unlike cases in criminal court, in the misdemeanor court, where the plea and the sentence are happening at the same time. It's very, very quick, much more quick than the more deliberative process in felony courts, as in this case. In this case, the defendant had multiple—
Shouldn't the prosecutor, be paying more attention, or the judge be paying more attention to the accuracy of the pleas here, to ensure that they are accurate so that a person is not— I think this is where he's actually pleading to a trespass, isn't he? Because it doesn't say with the intent, I think, with the intent to commit a burglary therein. Without that language, it's— yeah, go ahead.
Your Honor, ideally, all the parties would notice it is incumbent on the defendant himself, according to CPL 4705, to preserve the claims he wants to bring on appeal. With respect to, and in this case, I'd like to distinguish Lawrence. Lawrence is a case where the defendant was equivocal about the element that was discussed at the plea. It is well settled that if a defendant says something that negates an element of the offense, then the preservation rule is different than in this case. But in this case, the defendant's not claiming that he negated anything. The defendant is claiming that the court omitted a particular element of the offense, which is true, but under People v. Sieber, which is a Court of Appeals case, that alone doesn't render a guilty plea involuntary. The record in this case demonstrates the defendant wanted to plead guilty, the defendant knew what he was doing, and the defendant made an informed decision. He had consulted extensively with his attorney, received a beneficial deal, a favorable plea deal. He managed to avoid a significant amount of prison time, and he had lots of experience in the criminal justice system. When you look overall at the totality of the circumstances in this case, the court asked, "Do you want to plead guilty?" The defendant said yes. The court asked, "Have you spoken with your attorney? Do you understand the trial rights you're giving up by pleading guilty?" And the defendant confirmed that he did. When you look at the totality of the circumstances in this case, it demonstrates the knowing, intelligent, and voluntary—
The exception of the experience of the defendant, which I know some cases talk about, but I don't know that he's gone to law school and would have known that leaving that section out would have made a difference. But I think we understand your point. Thank you.
Thank you.
Thank you. Mr. Pantoja, you have 2 minutes, and I'd like you to address the fact that given the totality of circumstances, with the exclusion of him being an expert in criminal law, that he knew what he had an opportunity to talk with his attorney. He knew that he wanted to it was a burglary charge. He knew what had happened here and what was being discussed. Why is there any confusion, even though that section of the plea of the statute was left out by the court?
What I would say is that if we look at the totality of the circumstances, I think the most important circumstance would be the court's misdefining of the crime. And then additionally, the fact that we're dealing here with 2 felony pleas. These are serious cases involving state prison sentences and a 5-year term of post-release supervision. I think my adversary perhaps sets the bar way too low when we're dealing here with felony guilty pleas. I don't think it would have been too burdensome for the court when sentencing someone to state prison and having them plead guilty to 2 felonies to accurately define the crime that he was pleading guilty to and to inform him of all of the Boykin rights he was giving up. And in regards to his prior record, I would say that nothing in his experience, nothing in his past would have enabled him to understand or identify that the court had misdefined this error. And I think those factors are perhaps more important than those addressed by my adversary. This was not a minor omission, as I said, and as I think your honors had pointed out, is that the judge allocated him to a misdemeanor or perhaps non-criminal conduct, the violation trespass, and not to attempted burglary in the 2nd degree, is what he had agreed to plead guilty to. So for those reasons, I would ask for vacature of the pleas.
Thank you very much. Thank you both. Okay, we're going to go back up now. I hope that Mr. Deming is with us for A, children, or
Your Honors, can you hear me?
Children A. Children A. Yes, I can now.
Excellent. Apologies for the audio mishap before.
None necessary. Go ahead.
Your Honors, this is a case where the family's therapeutic progress was so substantial that the agency felt comfortable withdrawing its own termination petition, a position impossible to square with the family court's finding that the parents did not benefit from therapy or achieve insight, especially under a clear and convincing evidentiary standard. Counsel for the agency also submitted an affirmation saying termination was no longer in the children's best interest, and yet the court refused to even consider the agency's withdrawal attempt at disposition, where the entire focus of proceedings was what was in the children's best interest. These errors, among various others presented in our briefing, require reversal. The first error that I want to focus on is the court's error in finding by clear and convincing evidence that the parents failed to gain insight in spite of family therapist testimony to the contrary. During the relevant period, you have family therapist Maria Meyer, the only therapist to work consistently with the family, reporting in court that she made such significant progress with them that she could, in good conscience, recommend unsupervised visitation, that she reported improving family dynamics, and that they made enough progress to where the parents felt comfortable apologizing to the children, and the children.
This is Judge Cohen. Isn't that inherently a factual determination that a judge makes based on reviewing all of the evidence? And why should we, as an appellate court, disturb that very intensely factual finding made by the judge that the parents had not gained the appropriate insight into the behavior?
So, Your Honor, first, I would point out that the appellate division's authority to assess credibility is as broad as that of the hearing court under In re Michael B. But even setting that aside, you have a situation here where, again, the only witnesses to consistently watch the entire family interact gave glowing reviews of the parenting here, and that barely makes any appearance in the court's decision, in the court's reasoning. I think it is a glaring absence that you don't have a discussion of Maria Meyer's testimony, again, as the only person to be consistently interacting with all members of this family and watching the family dynamic. I would also direct the court's attention to the family court's application of what amounted to a full confession standard. They required the parents essentially to admit to everything in a list of fact findings, and essentially held that the parents were incapable of demonstrating remorse if they didn't essentially admit to a laundry list of fact findings from early in proceedings. And that's contrary.
Significant that they were not willing to acknowledge that certain things had occurred, which the children, all three children, consistently testified to certain quite dysfunctional behavior occurring, and the parents never were willing to acknowledge at any point that those things had occurred. And what significance should the court have given to that? Isn't that a very important factor for the court to consider in making that decision?
So, Your Honor, well, the court can consider it. I would say that here you have a family, unlike several cases that this court has looked at, you have a family, parents who admit to, the pattern of behavior, excessive corporal punishment, and, singling out one of their children. That is at the heart of the petition. The central aim of social services of the state and social services under social services law 384B is to reunite families, holding parents to a standard where they have to admit to every single factual finding doesn't achieve that goal, and it also overlooks binding precedent in.
They're not willing to admit to the actual behavior. Isn't there a concern that that behavior could occur again without an acknowledgement of what had occurred in the past? Isn't that a valid factor for the court to take into consideration?
Yes, Your Honor, it is. But here you have ample record evidence, and not just from the parents testifying that these behaviors won't happen again, but also from multiple therapists who work with them over years of proceedings, stating that these parents are not a danger around their children, that in fact, they have positive.
And of course, there are other therapists who say they are, right? This is not every therapist who testified said, yes, send these kids back. There was plenty of testimony from therapists who said, no, do not send these children back. It was not one-sided. So isn't that exactly what the trial court, the family court judge has to do, is listen to both sides and make a factual determination based on two competing views?
Your Honor, the family court does. However, I would say that, here we have the children's individual therapists who never saw them interact with the parents, saying that, they didn't want unsupervised visitation, these sorts of things. But not only are the parents' therapists testifying that unsupervised visitation should be expanded and that they're making substantial progress, but again, you have multiple family therapists, the only people seeing this entire family interacting, saying that, that visitation should be expanded.
So, counsel, the children are 15 and 13, correct?
I'm sorry, Your Honor?
The children are 15 and Patricia, I think the older one is 15 and the twins are 13, correct?
Yes, Your Honor, I believe.
And they all want to be adopted by their foster mom, correct? In fact, Patricia wrote a letter expressly stating that. And at 15 years old, she hasn't lived with her parents for several years, and she wants to be adopted. Shouldn't the trial court take that very much into account in making the determination?
So again, Your Honor, that should be taken into consideration. That being said, it isn't given dispositive weight in these cases. It's not clear that the children, the children are not saying they don't want to have a relationship with their parents. They don't necessarily grasp the legal ramifications of a label like adoption or, of opining on unsupervised visitation. I'm
not sure that was addressed.
Knows. I'm sorry, go ahead, Judge Ramos.
You know, I was just saying, I'm not sure that that was addressed. We certainly got a letter of clarity from the daughter, as Justice Scarpula has already referenced. We have to look at the best interests of the children. These are teenagers at one of the most vulnerable times in their lives. And, certainly this case has gone on for too long, and that's very unfortunate. But we are faced with a set of circumstances, one being the age of these children, that cannot go unnoticed. And to suggest to the child that's 15 or even 13 doesn't understand what adoption means, not to be living with your parents anymore, is a very different thing. That doesn't mean they can't have a relationship of some sort if that's determined to be in their best interest, but I haven't seen that they've requested that. They've requested adoption.
So, Your Honor, they've maintained contact, with their parents, texting. Their last virtual visit was midway through June 2020, and virtual visitation would have continued if, the agency had reached an agreement, but the parents have continually sought that out. I think it is a highly unfortunate situation with respect to how this is developed, but again, it's not a reason to deprive the parents of their fundamental right to parent their children and to take a close look at the various errors that I think infected the family court's reasoning. We're not just at disposition, but also at the fact-finding hearing where they found the parents had permanently neglected the children in the first place, again, by a clear and convincing evidentiary standard.
Okay, thanks.
Your
Let's
Honor,
get to the, you have some
yes,
rebuttal time. Let me hear from Mr. Berman.
Thank you, Your Honor. Good afternoon. May it please the court, my name is Jeffrey P. Berman, and I represent the respondent, Cardinal McCloskey Services. Contrary to the arguments of their attorneys, it's extremely clear that the parents did not take responsibility for their actions.
Well, counsel, I mean, the parents did take some responsibility. That's not fair either, because they complied with the agency service plan. They completed their parenting skills and their anger management classes. They initiated and they participated in individual, joint, and family therapy. They attended all their supervised visits with the children. They sought to make up visits when they needed to. They attended the parent-teacher conferences. They attended the doctor's appointments. So to say that they didn't make any effort, or to say that it was, that they didn't do anything that they were supposed to, is just grossly unfair. What's being asked here, and what counsel is pointing out, is that they're being asked to admit to each individual thing. They say that they did apologize. In fact, I think the therapist said that there was a breakthrough in therapy back in 2014. So they have made efforts here.
Right, Judge. The agency is not contesting that they took the actions by going to their services, by visiting with the children. However, the big problem here, and which I think is the major flaw in the appellant's argument, is that when asked what they were taking responsibility for, they wouldn't say. They would only say that the mother said that she took responsibility. She was very sorry for hitting Hiram in the leg with a stick and for treating Hiram differently than the other children. When she was asked about the most serious allegations, such as the fact that she made this 4-year-old child stand on a stool and then
kicked it out from underneath him, or eat the banana peels.
Right. Mm-hmm. And Your Honor, she denied it. Even 7 years later at the dispositional hearing when she testified, still refused to admit that it happened. The father, in his testimony, went so far as to make up a story that these children must have mistaken that incident, or those incidents, for the children, for Hiram climbing up on a fort of furniture that they made, the father then picking him up off that fort, and the father then kicking it over. Clearly an incredible statement. And throughout the proceedings, they never would acknowledge that happened. Similarly, the other serious allegations, such as feeding Hiram banana peels while he had to sit on the floor while the rest of the family ate dinner at the dinner table, they denied it. Said over and over again, were asked repeatedly, if that ever happened. They said no. Never
Or the
happened.
fact that the child had a distended stomach, I think. But so should this not be a case, since they did have this breakthrough and since they've been since they've followed some of these issues and are still going through therapy, should there not be a suspended judgment or something in that case, so that they can continue to see if they can get to the point that they need to be, rather
Absolutely.
than this?
Sorry, just absolutely not.
No.
It's been 7 years that they have been doing this. They have, between the fact finding and the dispositional testimony was about 3 years or so. They continue to say exactly the same things. This supposed breakthrough was in 2014, and 5 years subsequent to their supposed breakthrough, they're still refusing to admit to these allegations. It wasn't so much the judge was forcing them to make admissions or go down a checklist. She was just, understandably concerned that how could they take responsibility for their actions?
You wanted to make sure that this wouldn't be repeated, that any of these acts wouldn't be repeated, and that the children would be not be emotionally harmed going forward.
Well, also, how could the parents, how could the family court find that they've truly accepted responsibility if they couldn't even acknowledge that they consented to these findings? And these, the parents are they're very smart, they're very sophisticated. They would never consent to findings that they, in my opinion, did not believe to be true. And to further this point, Your Honor, I think it's very important to point out that there were certain allegations in the abuse petition that were not consented to as part of the fact-finding order by Judge Weinstein, which one of those was that Hiram's teeth had in fact rotted. And the fact that they did not consent to that finding being put into the order shows that they were unwilling to consent to findings that they truly did not believe to be true. They consented to the findings, such as the stool being kicked out from under Hiram, Hiram having been forced to sleep on the bed, in the bathroom by the toilet.
Yes, we're familiar with all of the facts.
Yeah. So those are all things they were represented by counsel. They consented to the entry of these findings. Yet 7 years later, they're still saying that they're false, or at least the vast majority of them they're saying are false.
Thank you. Let me hear from Ms. Egger. Thank you.
Thank you very much.
Good afternoon, Your Honors. These kids have been living with their pre-adoptive foster mother for 8 years, almost 8 years, and they left their home with their parents when the boys were not yet 4 and Patricia was 6 or almost 6. And after a history of horrendous acts that the parents engaged in, and I know they brought up that the mother was born in China and that there are different standards there, but I find it incredible that parents in China would do such things to a child. He was less than 3, Hiram, when the stuff that they were doing began. And in addition, it was not simply excessive corporal punishment. It constituted this psychological demeaning of the children of Hiram that would have been that was extremely destructive to the siblings, to see this little boy getting not having a place to sleep, not being able to eat with the family, degradation, humiliation. That is just not part of any parent's acceptable behavior. And as for the therapists, I pointed this out in the brief that in their testimony, they were less than positive about the parents. They admit, Miss Myers said she never recommended that they go home to the parents. And Ms. Weaver, who was only in her first, this case was her first time as a family therapist, but she said that she couldn't say that the children's best interest would lie in being reunited with the parents.
Counsel, Do you agree that the children understand the difference between being adopted by their parents and or going home? I mean, there's no question they know what's going on.
No question whatsoever.
It's not, the legal definition is not, they know what the deal is, right?
They've been living with this other person for 8 years. And the father is telling to me that in his testimony, when asked, what do you think they're getting in the foster home, you know, that is a benefit to them? He said nothing. He could not acknowledge that the kind of acceptance and positive feelings that they had about the foster mother were based on anything that was.
And it's your experience still that they wish to be adopted?
Absolutely. Our social worker and our trial attorney are in close contact with the children, and they have for years, starting in 2017 at least, if not earlier, when they decided they didn't want to attend visits and they dropped out, and they didn't want to go to the family therapy anymore. That was between February and the fall of 2017. They never really bought into this breakthrough thing, which is the term that it was the father repeatedly used. And the therapist, the family therapist.
I think it was Maria Meyer, the family therapist, actually, that used the breakthrough language.
Okay, but it was the father who repeated it over and over and over again. And the family therapist in her testimony also acknowledged that things were not, there could have been this breakthrough, but it didn't mean everything was okay. And the children did not ever feel that this was like everything's going along.
So what about a suspended judgment? If it was a breakthrough, but was just the beginning, what about a suspended judgment to continue their progress?
Well,
attempt to continue.
This has been way too long, and there's a limit to how much these parents seem capable of understanding, and the children don't have any reason to want this to be continued, this limbo where they've had all these years of experience and they want to stay where they are.
Thank you. We are back to you, Mr. Deming.
Thank you, Your Honors. So appellees want to draw a lot of attention to the initial allegations, which are serious. However, in 7 years in the interim, including across a key period where, again, the evidentiary standard for the court was clear and convincing evidence, you have the agency not only trying to withdraw the termination petition, which belies any claim that the parents made no therapeutic progress, but you also have the agency submitting an affirmation saying that it was in the children's best interest to withdraw the termination. And yet the court didn't even consider that when at disposition, the best interest was the main focus. I would say that the therapy testimony speaks for itself. I would invite the court to review Maria Meyer's testimony because she did report on breakthroughs. She reported on a positive. Yes, Your Honor, and that is during the relevant period when the court was evaluating whether or not the parents had committed permanent neglect. These are breakthroughs that the parents made within the period that should have been considered under the clear and convincing standard. And again, the court just largely ignored the fact that you have the family therapist, the only person looking at this entire family and working with all of them, saying that the parents had made substantial breakthroughs. And the fact that you have not only the therapist, you have the caseworkers from the agency, Reina Mendez, and then finally culminating with the agency itself trying to withdraw this petition. Clearly the parents made progress here, and the court just did not pay attention to it. The parents' rights to parenting their children are fundamental ones, and there's a reason we use the clear and convincing standard in these proceedings. And just quickly to the point of, the children's current wishes, I don't think they've indicated that they, wish to have no relationship with their parents, and yet that is essentially what they're facing now. I mean, their virtual visits ceased in June of 2020, and my understanding is that's because, they were shut down by the agency and the foster mother. You have children who've been interacting positively with their parents for 7 long years of proceedings, over which the parents have continually sought to expand visitation, have showed up to, every single school event related to the children, and have done substantial work on themselves. And to have all of that essentially go without recognition by the family court, it deserves another look.
Thank you. Thank you.
Thank you,
Thank you. Thank you all. Zittman versus Sutton LLC.
Yes.
Yes, Your Honor. Thank you.
Good afternoon.
Good afternoon.
May it please the court. I'll tell you, this case is not as interesting as your prior case, but when I was last here before this court, prior to the pandemic, there was in place the Housing Stability and Tenant Protection Act, which had been enacted and permitted tenants to look back more than 4 years to see if there was any evidence of rent overcharges and a landlord's intentional evasion of the rent stabilization law.
But there had to be some allegations of fraud. There had to be some allegations of fraud. If there were allegations of fraud, then you would have the look back. I don't think that changed at all. So I guess the question is, what's the allegation of fraud here? What's the evidence of fraud?
Okay, well, I'll get to that, Your Honor, in a moment. This court reversed the dismissal, pre-answer motion to dismiss by the defendant, sent it back. After it was sent back, the Court of Appeals decided Regina.
Okay.
And no sooner was Regina
I got all that. I'd
decided.
like you to answer my question now rather than after when you're ready.
Okay, sure. So when we talk about fraud, let me count the ways that the record shows what happened here. This landlord, Maya Greenberg, was the principal of the defendant respondent's predecessor, issued standard leases to tenants of a rent stabilized apartment.
So from what I understand, the first tenant in this apartment was a Mr. Lenman or something like that.
Lauman, yes.
Lauman in 1985 had a rent of $704. And then there was a Mr. Moore in 1985, 87, and he had a $1,600, and then it went to $1,704. And then the plaintiff, present tenant, came in 1988. And he was told that the rent was, I think, $1,800, that there was somebody there. It was maybe that was correct. Mr. Moore that was told to. I'm not sure. But first his rent was $1,800, and then they reduced it to $1,200. Shortly after they told him it was $800, they reduced it to $1,200. They registered at $1,200. It's continued to be registered at $1,200, right?
He paid
I mean, not continued to be registered. I'm sorry, they continued to register the rent from that time forward, right?
He got a preferential lease after he complained. He talked to the landlord when he got his standard lease.
But DHCR has registered that rent has been registered. The landlord has registered that rent since it was at $1,200. Is that right?
Let's go back.
So let me just ask you this: what is the fraud there? What is that's what I'm asking.
Sure. This man, the plaintiff, received a standard lease for $1,800, and he paid $1,800. All right, that's what he did. The landlord filed with a state agency, DHCR, and told DHCR this man received a rent stabilized lease for $1,200. That was false. That did not occur.
Counsel, let me interrupt for a second. What about all of the cases from the first department which clearly hold that an increase in rent alone or an overcharge of rent alone is not enough by itself to establish fraud? The kind of fraud that we're looking at is the kind of fraud where you're forcibly trying to take out of rent stabilization.
Mr. Marino, I'm going to ask you to mute, please.
What do you have here other than that too much rent was charged and was brought to their attention, they corrected? Why does that reach to the level of a fraudulent scheme, which is the exception rather than the rule? It's an unusual situation. Normally, the mere fact the overcharge is not enough.
Yeah, Your Honor, you're absolutely right. When you talk about your case decisions as you've issued in 435 Central Park and when you've issued this Montera versus KMR, one of the things you point out that the concept of fraud is very broad. And when we talk about fraud, we're talking about false filings, false giving of information, false documentation. When this landlord involving not only Mr. Zitman, but his predecessor, he had a rent stabilized apartment in his building. And he gave these people purposely standard leases, knowing perfectly well this was illegal. This was improper.
What evidence?
That's fraud.
Counsel.
That's
Counsel,
fraud. Go ahead.
I understand you're saying, I hear you saying that it was illegal, that he knew, and that he knew that it shouldn't have been. I don't know what evidence there is on the record that he knew that he shouldn't have done it rather than it being an error.
Well, because Judge,
that seemed to be corrected. Well, how long was it between the time he had $1,800 and the time he had the $1,200? I mean, what period of time are we talking about?
We're talking about 12 months. We're talking about almost 12 months, Judge. Almost 12 months. And the interesting thing is that when
what
Mr. Zitman,
is there that was intentional, or it was not just?
Yes, it was intentional. Let me explain why. Because if you look at the verified complaint, which is verified by the plaintiff, he says at some point, one of the tenants in his building had occasion to have a conversation with the gentleman and said, by the way, welcome aboard. And what are you paying rent, if you don't mind me asking? And Mr. Zitman shared. And the tenant said to him, you got to be kidding me. You're paying $1,800 a month? This is a rent stabilized apartment? Mr. Zitman contacted Mr. Greenberg, Meyer Greenberg, the principal of the landlord, Sutton. Mr. Greenberg invited Mr. Zitman up to his office. What happened? Mr. Zitman said, I've heard from a prior tenant in my building that I may be paying too much. And Mr. Greenberg, what did he do? He pulled out a phony lease. And he said, what do you mean you're paying too much? Are you kidding me? Look what the prior tenant paid. Look at this standard lease, sir.
Thank you.
And Mr. Zitman, go ahead.
I was just going to, if you wrap it up so we can move over to Mr. Cullen, you'll have a rebuttal time. Okay, you want to wrap up that last statement you're making?
Well, the point is, it reminds me as a former prosecutor, this is like a Bernie Madoff type situation, doing an analogy. When somebody questioned Mr. Madoff about financials, what did he do? He pulled out documentation that was phony, like a $3 bill. When Mr. Zitman questioned the landlord about this lease and the amount he was paying, he pulled out phony documentation and said, what's your problem? You got a good rent.
Thank you. Mr. Marino?
Yes, Your Honor. Thank you.
Why don't you begin there? Why shouldn't counsel be entitled to the look back based on his allegations of fraud here?
Well, that's all that exists, Your Honor. These baseless allegations. There's no evidence to establish a fraudulent scheme by the landlord to deregulate the apartment. This whole story about how the plaintiff met a Maya Greenberg, and by the way, Your Honor, Maya Greenberg was first mentioned, that name was first brought to the attention in the brief. It was never meant, there was no Maya Greenberg ever mentioned with the lower court. But this story, how after a few months after taking occupancy, a tenant told him he was being overcharged. That's a story. There's no proof of that. Then he says he spoke with Maya Greenberg, and he only mentions that name in this particular brief. So I don't believe that the court should even allow for this testimony about Mr. Maya Greenberg, because he never existed with the lower court. But he then explains how then Mr. Greenberg presented a lease in the name, quote unquote, Gold at $1,119 per month. There's no evidence of this. There's no lease, and there's no Gold lease presented, nor is there Gold, a name of Gold on the registration. This is all a story, and it's a story that they feel compelled to tell because they have to create a fraudulent scheme to deregulate the apartment. The only true evidence that exists, Your Honor, is the DHR rent record. And yes, there are fluctuations in the rent, but as the court stated, that increases of rent alone on its face is not proof of fraud. So they are now relying on a story. Everything that counsel told you, Your Honor, on how the plaintiff met with Mr. Greenberg and Mr. Greenberg said X, Y, and Z, there's zero proof of this. It's only a story. And I believe the lower court agreed in finding that there's no evidence of a fraudulent scheme to deregulate the apartment. The rent was, in fact, counsel's allegation that plaintiff paid $1,800 a month for a year is another story where there's no evidence. Never once was there any proof of any payment of $1,800. In fact, when you read the complaint, it sounds like it was after a few months when he first discovered about this alleged overcharge. These are all just stories, and they need this story, Your Honor, to be able to somehow create fraud. The truth is, Your Honor, in 2016, when this case started, my office had previously started a non-payment proceeding that ultimately went to trial, in which the petitioner prevailed. But the fact of the matter is, this case started in 2016, and yet plaintiff still argues that he first found out about the overcharge in 2016. That's clearly inconsistent with the previous statement where he said that after a few months of being in the apartment in 1988, he discovered an overcharge. Your Honor, as I stated, the lower court correctly dismissed this overcharge case because they found that there was no evidence of a fraudulent scheme to deregulate the apartment by the landlord. And as such, there's no basis for an overcharge. The case was correctly dismissed. Thank you.
Thank you. Mr. Elan? I think he had a little difficulty, might have been bumped off.
You're muted.
Ah.
Okay, you may begin.
You're muted.
God.
You're still muted.
I can't see him.
I see him. He's muted.
Do you hear me now?
Yes.
Yes, we hear you.
You're muted again.
After you click, move the cursor away from the microphone.
Here. Now. I'm good?
Yes, now, yes.
Okay, jeez. Thank you. Thank you. Listen, the record, despite what I've heard from defense counsel, if we look at the record at page 195, there are DHCR filings by Sutton, the principal. Everyone shows from Mr. Malman to Mr. Moore to Mr. Zipman, rent stabilized leases, all false except for Mr. Malman. Not true. These people, Mr. Moore and Mr. Zipman, got standard leases. Now, If you look at the record at page 39, there is.
Oh, you're muted again. You're muted again. You're muted again.
You hear me now?
Yes. Keep
Thank
the
you.
cursor away from the microphone.
I won't touch it.
Yeah, well, just move
I
it
won't
away,
touch it.
or else it might just vibrate over.
Got it.
No idea.
Okay.
Okay, go ahead.
Thank you. If you look at page 39 of the record, okay, there's a standard lease. Whose name appears on behalf of the landlord? Who else? Maya Greenberg. And when counsel says, oh, this was never part of the record, please give me a break. This has been part of the record from day one. If we look at page 169.
You're muted again. So.
Didn't touch it. I didn't touch it. When you look at the record of page 169, are you with me? Yes?
We're with you.
Oh, okay. You'll see that when
have 1
Sutton,
minute, so it's
I know when Sutton
running
sold the property, you will see the person who signed off was Maya Greenberg's daughter, Joan Greenberg. She signed the lease, the deed in favor of the present defendant. Look, the bottom line here is, in my opinion, given the underlying facts of what happened at the get-go, when this gentleman took occupancy, and what happened before and what happened afterwards, it demonstrates clearly evidence of a fraudulent scheme to overcharge, a fraudulent scheme to avoid the rent regulations, the rent stabilization law. And the seriousness of this is, as a former prosecutor, when we go back in time and we discover evidence that connects somebody with an event that occurred years ago, we don't turn the book and close it and say, it's old. We're not going to go back. No, we don't do that. We're looking for justice. In this case, there is evidence of fraud. No question.
Thank you. Thank you, Mr. Alon. Thank you both.
Thank you, Your Honor.
Waverly Stores versus Waverly Muse.
Good afternoon, Your Honors. For Appellant Waverly Muse, Stephen Kirkpatrick, may it please the court. This is an appeal where a building owner, a residential cooperative, is simply seeking to enforce the terms of its commercial lease and require adequate insurance to be maintained. In December of 2017, the cooperative...
Counsel, after the parties entered into the stipulation, there was supposed to be a chart attached to the stipulation that set out the terms of whatever the agreement was. That wasn't done, though, was it? And without that, how do we determine the terms of the agreement in terms of what insurance there was supposed to be in the circumstances?
Your Honor, so that is not correct for multiple reasons.
Okay.
First of all, the chart, and this is shown in the record at pages 802 and 803 of the record, there is a email from Brian Bentley to prior counsel for Waverly Stores sent on September 21, 2018, providing a copy of the chart. On the copy of the chart that is filed in the record, there is shading. However, as stated in the reply brief, there is a more clear copy of the chart, which is what was provided with red highlighting, that was so everything was visible, and that is shown at page 847 of the record. And documentary evidence shows that that chart was provided prior to the stipulation being entered into.
Was it with the stipulation? It said in the stipulation that it was attached, but the question is not whether it was in the reply or whether it was somewhere else. Was it attached to the stipulation?
Your Honor, it was attached. I don't know what, I was in court when the stipulation was executed. Prior counsel for Waverly Muse was in court. Waverly Stores. Waverly Stores principal was in court. There was extensive negotiation. The chart was, everybody had a copy of the chart. It was simply not included for whatever reason when the court so ordered the stipulation. But in the stipulation,
Counsel, isn't it undisputed though that if the chart was not included with the stipulation when it was filed in the court, that's undisputed, right?
what's undisputed is that a copy of the chart was not included with the stipulation that was filed by court staff.
Okay, but it wasn't included.
That's what I was asking.
Court go back and reference it to determine, as a matter of law, what those reasonable requirements were if the chart was never attached to the stipulation that was filed with the court. How could it become part of the official court enforceable stipulation?
Well, it's part of the official court enforceable stipulation for several reasons. Number one, in the stipulation, there's an acknowledgement that the chart was received, number one. Number two, there's, as I stated before, at pages 802, 803, and 847 of the record, there's documentary evidence showing that a copy of the chart was in fact provided to Waverly Stores Counsel prior to the execution of the stipulation. So, and furthermore, what the chart addressed is the status of compliance. As to the insurance requirements, those insurance requirements, and that's really the key issue. The insurance requirements were set forth in the December 26, 2017 notice that was provided. That was what implemented the heightened insurance requirements. That notice was again attached as part of the notice.
It's the mere fact that the landlord said these are the new requirements we want doesn't make it so under the lease. The lease, to be frank, is very unusual to me. I've never seen a lease like that, but it doesn't say the landlord can on its own decide what the new requirements will be, and those are the enforceable requirements. It says that they have to impose reasonable requirements, and if the parties don't agree, then a court has to make a determination what's reasonable. And you're saying, court, look at the stipulation and the chart annexed thereto. We agreed what's reasonable, but if we don't have the chart as part of the official record of the stipulation, how can the court, as a matter of law, make that determination?
Once again, Your Honor, the way the court makes and the court did make the determination. There was a settlement. This is a Yellowstone case. There was an order to show cause, and the order to show cause was decided by the so ordered stipulation. And the so ordered stipulation, number one, acknowledges that the chart had been received by all counsel. Number one, there was an acknowledgement. Everybody agreed that they had gotten the chart. Number two, documentary evidence in the record, which is the email, shows that the chart was circulated months before the stipulation was entered into. And there's no dispute as to that. That's all shown by documentary evidence. And moreover, again, the chart showed the status of compliance. The requirements were imposed by the December 2017 notice, and that was also in the record. It was part of the cure notice. It was part of various submissions.
You, Justice Scarpula, you're muted.
I muted myself on the last case, and then I forgot to unmute. But anyway, when you say the chart shows status of compliance, I thought the chart showed what the new insurance requirements were. Is that not correct?
That is not correct.
So you were saying you prior to the stipulation, you said increase the insurance?
That's correct.
And so they had a right to, under the lease, to object, and they did, correct?
Well, no, that's not correct. So
they said nothing. They said, sure, we're gonna do 50 million each time.
So what
if you ask us for whatever you ask for, it's all good. Because that's not really what the other side is saying.
Your Honor, what they did was after the December 2017 notice was delivered, they did not.
No, we're talking about a stipulation that is previous to that with a chart, right?
No, Your Honor, no. So the stipulation was entered into in October, either October or November 2018.
Right,
The
November
notice-
8th, 2018, and that has a chart. Now,
and
that chart,
there's a chart,
right?
and that chart shows the insurance compliance summary as of September 21, 2018.
Meaning
The notice.
that prior to that stipulation, you raised all the insurance rates and they agreed to it all?
They did not respond to it, and that was why the notice.
No. So clearly there was a dispute because you don't need a stipulation if they said, sure, we're going to raise all those insurance policies, right? Can we not agree on that? They did not agree to all the new insurance requirements, and that caused you to go into court and execute a stipulation. Am I wrong about that?
I believe you are wrong, Your Honor. I believe what they did is they neglected to comply with the insurance requirements. There was nowhere did they say prior to commencing the case. There's nothing in the record. They never wrote to the cooperative and said, we don't think these are proper. We think these are excessive. That never, ever happened. What they did is they simply sat, did not respond. Time went on. There were follow-ups. There was an April follow-up that we sent out, April of 2018, before the default notice was sent. Please give us the insurance.
Counsel, when you made your motion for summary judgment, it was your burden to show lack of compliance with the stipulation, right?
Yes, that's correct,
You
Your Honor.
made that motion for summary judgment and you attached a copy of the stipulation which you claimed was breached. Did you attach the chart to your stipulation in your motion for summary judgment?
All of the.
No, did you or didn't you attach the chart to your motion for summary judgment?
What we attached, we didn't add in the chart to that stipulation.
Okay,
but
so counsel, if you didn't attach, if you didn't attach the chart to your motion for summary judgment, how could the court decide as a matter of law in deciding your motion for summary judgment whether or not the other side had or had not complied with the stipulation, including the chart, when it didn't have the chart before it as part of its record?
Your Honor, that's not correct. The chart was before the lower court. The chart was filed. It was part of the record. I wasn't going to misrepresent and add into what was part of the stipulation, a chart that was not attached.
Okay, Mr. Kirkpatrick, we've been going on this issue for quite some time. I'm going to move over to your opposing counsel unless any one of the justices has a question for you again. Okay, let's hear from you, Mr. Rabinowitz, and you'll have some rebuttal time, Mr. Kirkpatrick.
Thank you, Your Honors. May it please the court, I think you've hit upon one of the central issues in the case, which is that there was no chart attached to the stipulation. So under the doctrine of definiteness, how does the court enforce this? And in fact, when they moved for summary judgment, the chart they attached was not the September 2018 chart. It was a December chart. And that chart is different from the one that it was only on, I believe, their reply motion, reply papers on their summary judgment motion that they finally produced. What they say was the September 2018 chart. And that chart is different from the December chart.
Counsel, this is Judge Scarpullo. Do you agree that under the stipulation, you had a week to object and you didn't do that?
I don't agree with that, and I'll tell you why.
So tell me why.
First of all, to be clear, the only record that we were able to locate was, I think about 2 weeks later. So we did not meet the 1 week deadline.
You did? Okay, so you do agree with me. You had a week and you didn't do it.
But what the stipulation says is it's the failure to meet and confer that renders whatever the requirements are reasonable. It's not the filing of the objection. And what opposing counsel has done is they've created this condition precedent of a detailed exegesis about what's wrong with the reasonableness of the insurance requirements when there's no such thing in the stipulation. nor is it a condition precedent. And this court has held time and again that in order to find a condition precedent, there has to be clear language in the contract, or in this case, the stipulation, and there's no such thing. The only provision that says that the requirements will automatically be deemed reasonable, again, whatever exactly they are, is if there's no meet and confer. And we did provide evidence that we had objected, that we had sought a meeting, and that the response from the board president was, we're not interested in meeting with you. Look at the requirements. That's what you have to do. And as we've pointed out in our papers on this appeal, in our brief, by very definition, all of the requirements almost all of the requirements with respect to the subtenants that Waverly has are unreasonable, because the lease says very clearly that the only insurance that can be required of Waverly Store's subtenants is general public liability insurance. And they went ahead and said, no, we want automobile insurance. We want workers' comp. We want alcohol liability. There's no authority for that under the lease whatsoever. And it wouldn't make sense for there to be such authority, because those at the time the lease was entered into, we were already had 7 subtenants. We already had existing leases. And it was only in new leases that it provided that the landlord could say, look, we want to have a reasonable amount of general public liability insurance from your subtenants. And that they could ask for, but they couldn't ask for all these other things. So the idea that there was no dispute as to reasonableness doesn't make any sense, particularly since we filed a complaint seeking a declaratory judgment that we weren't in breach of the lease. We got a Yellowstone, and so we were actively contesting that. And if you read the stipulation, as the court has, you see then that it's certainly contemplated in the stipulation that there will be a back and forth, and that the trial court may have to weigh in if we can't come to an understanding as to what's reasonable. This was always to be a back and forth process. And in fact, what happened here is, from the very inception of this case, the position of the landlord has always been, you have to cure, you have to cure. We want more insurance. We want more.
Thank you. If you could wrap up. Thank you.
Yes. What I want to say is, on the incurability point, that whole doctrine of law is utterly inapplicable here. Because in those cases...
Let me just ask you one question. Is it your position that the only thing that you haven't complied with is the new insurance requirements, that you can show that up until the new insurance requirement, you complied, and you have proof that you complied throughout the lease with all the insurance requirements prior to the...
I would love to make that representation to the court. I can't, because we're talking about almost 40 years.
I guess that's the big problem, right? And at the trial court, if you can't do it, you're out anyway. So
well, I have an answer for you, though. It has never been the landlord's position that we didn't. And we were in place for 40 years of this 99-year lease.
I think they just served 2 notices of default, right? That says you haven't complied with your insurance requirements.
The notice of default was based on the new requirements, not based on any existing ones.
Okay.
There's never been an issue in the case during the first 37 years of the lease that we were ever out of compliance with the insurance.
Okay, thank you. Mr. Kirkpatrick, you have a minute.
Thank you, Your Honor. So I'm now returning to address the open question. Pages 113, 114 of the record, the stipulation at paragraph 4 of the stipulation, the last sentence states the insurance deficiencies. So it says deficiencies, not requirements, and that's a key word. The insurance deficiencies are set forth in the chart annexed here too, which was provided to plaintiff on September 21, 2018. So it recited that it was provided, and it in fact was provided, because a copy of the email that was sent providing a copy of the chart is included in the record at pages 802 and 803 with another copy of the chart at 8:47. So it was clearly before the court. And the reason that the stipulation, so there's no dispute that they had the chart, they acknowledged getting the chart. And what the reason that the stipulation was structured in the way it was, this was not about having a back and forth, because Waverly Stores, if they had it up to them, they'd be having a back and forth for the next 40 years, and they would never provide more insurance, and they'd never do whatever else they had to do, because that's just what they do. They get a notice, they get a demand, and they sit back and they do nothing, and they don't respond, and they don't object, they just radio silence. And that's what happened here. We provided the requirements December 2017, did not hear back. April 2018, we sent a follow-up. We have these new requirements, please comply, please provide the proof of insurance. Again, nothing. Then in May 2018, we served a default notice. They waited, it's a 60-day, a very long default cure period. They waited until day 57, and then they went into court and they sought the Yellowstone injunction. And that's the very first time that they, quote, disputed these requirements. And then there was a stipulation, and it provided a clear path forward, not to discuss for the next 30 or 40 years and, you know, have a back and forth and never come to any conclusion, which is what they'd like to do. There was a conclusion because the co-op wanted to be protected. They wanted to have an upgrade in the insurance that had not been done since 1980, and they are entitled to that. And all of the documentary evidence is in the record. There was, even though the copy of the chart was put in on reply, there was a surreply, there was a surreply. The lower court allowed extensive briefing. Any of those procedural issues.
Thank you, counsel.
All of the documentary evidence was before the court. Thank you, Your Honor.
Thank you. Thank you both.
Thank you.
That was the last case of the afternoon. Thank you very much. Court is adjourned.